So we will wait just a few minutes because I know a lot of people are just joining now, but good evening, everyone. It's very nice to see you all. If you can put your videos on, that would be even better. It's always nice to see not just your names. We already see your names on the listserv. It's nice to see you by video as well. And my name is Maya Shukeri. I will be moderating tonight's presentation with our special guest who I think everybody knows by now, Kyla Lee, who has already presented for WiCCD. She's out of BC, but Kyla actually has a niche in impaired driving. This is almost exclusively what Kyla does. So she knows all about impaired driving cases, which have become very challenging, as most of us know. The defenses are really very difficult. Charter applications are sometimes challenging depending on the case. And that's why we have Kyla here with us for the next coming weeks to talk specifically about impaired driving. And the way we're doing this is today, session 1, will be focused on the common charter issues that we find in impaired driving cases. The next session will deal with defenses because, sometimes there are no charter issues. And so what do? Sometimes the case ends at the charter issues, and sometimes you can still have defenses. And that's what Kyla will be talking about in session 2. And session 3 will be about the sentencing issues that we deal with and collateral consequences specific to impaired driving. So we have really one of the best people to talk about this topic with us tonight and for the next coming weeks. And it's very nice to see everyone here. This session is recorded, so you'll have a copy of the recording after later on. And each session counts for 1 hour of professionalism. So we are already getting our CPD hours. That's for Ontario. I think in some jurisdictions, you guys have also been able, I think in BC, to also claim the CPD hours for WiCCD. So I see it's 7:33. I will still be admitting people, but Kyla, if you want, you can start and the floor is yours.
Okay. Hi, everybody. Thank you so much for coming. I'm kind of overwhelmed at how many people are here, so it's very kind. I am going to talk to you about common charter issues that arise in impaired driving cases, and I have prepared a slideshow that I'll be using to go through it. I've got lots of case law. Sorry, it's going to be boring. I'll spice it up, I promise. But I also know that like people's sort of experience with impaired driving cases can vary widely. So I've tried to do like a really broad spectrum of looking at the charter issues, from the ones that are probably really obvious to most people to the ones that are kind of a little bit more nuanced and a little bit lesser known. So apologies if some of this is already something that you know. I'm trying to cover everything. So I'll share my screen here. Sorry, that's not the share screen button. And don't mind if you get a bunch of my Slack notifications because those tend to come up. All right, now I have to move this. Okay, view slideshow. Okay. So this is just the title page. So the way I look at an impaired driving case is that literally everything is, oh, okay, it's doing an automatic thing. The way I look at an impaired driving case is literally everything is a charter issue. I try and make a mountain out of a molehill if I can when it comes to anything that could even possibly be the tiniest of breaches. Because actually I just had a judge say this to me in a pretrial today, that you get a judge that's in the right mood and doesn't like something about what the Crown's doing or a decision the Crown made in charging the file, and they will take it and run with it, even if it's something where it wouldn't be a big issue. So I plead everything and throw it all at the wall and see what sticks. I know lots of people say pick your top 3 issues or pick your best issues. I think that's great for lots of different types of practice. I don't think it works well for impaired driving practice, and I think you need to plead everything. So here are the common charter issues that I'm going to deal with. So number 1, traffic stops and detentions, then validity of demands, offering/implementing the right to counsel, reading and advising 10A.
Yeah, it's spicy, eh? But it's good, eh?
Bodily fluids and what gets done with them. And then medical evidence. So in those situations where people are going into a hospital or getting production orders, that type of thing, medical privacy, charter related issues. So almost every impaired driving case starts with a detention of some sort. I mean, sometimes they don't. Every once in a while, you get the like weird case where there's like a civilian complaint and the police don't find the person, but they go back and they track it all down through, statements from servers, and they lay a straight impaired and they don't have readings. Those are extremely rare. Most of the time, you're going to have somebody who's either in an accident or is stopped in some manner. And so it's starting with what is very obviously a detention. And so the grounds to conduct a traffic stop are a big issue that we deal with in these cases often, and something that can actually have a lot of legs charter-wise. And I don't think people argue validity of traffic stops in impaired cases as thoroughly as they should, because we often don't even think about the rules of the road that we're told. I know what I'm taught to do when I'm driving, what I was taught when I took my driving lessons, but those aren't actually necessarily the law. And so there's lots of times where you'll have police officers pull somebody over for some sort of traffic violation, whether it's a Motor Vehicle Act violation or a Highway Traffic Act or Traffic Safety Act, depending on where you are. And they'll say, I'm stopping this person to investigate this, but that's not actually a lawful stop. There are often cases where police officers are mistaken. The one that we get really common here in British Columbia is people making turns, because under the Motor Vehicle Act in BC, you only have to use your turn signal if your turn can affect other traffic. So police will they'll be parked somewhere writing their reports, and they'll see someone pull out of the parking lot of a bar and they won't signal their turn, and then they'll pull them over for the moving violation. Now we all know why they're really pulling them over and why they're sitting there writing their reports, but that's what they're saying to justify their conduct. And so they can't use some other fallback when they've already written it down and committed themselves to it. So read the provisions of the Motor Vehicle Act or Traffic Safety Act or whatever the equivalent is in your province. If the officer says a moving violation took place, go and read the law. Lots of times too, for things like your busted tail light, you'll find that the regulations only require a vehicle to have a certain number of functioning tail lights. So one being out might not necessarily be a violation. Tinted windows, that type of thing. Certain provinces have allowable levels of tint. So go read the statute and look at what is in your province's legislation for the actual basis of the traffic stop for any moving violation, because oftentimes the police will have it wrong, and then you have right away an arbitrary detention. That's pretty bad when they don't know the law, so you can get away from 24/2 problems. There's also the situations of random stops, and of course, random stops, you should always I always plead them as not truly random, whether it's, that it was a targeted stop for issues of profiling or some sort of a ruse. There's lots of case law on this, lots to explore. And a truly random stop is a very rare thing. And in fact, there's some jurisprudence that suggests that the only sort of truly random stops are the roadblock or check stop scenarios. So, roving stops are on the chopping block. There was a decision out of Quebec that I'm sure everybody heard about, where roving random traffic stops were found to be unconstitutional for the purposes of permitting officers to investigate sobriety, because it was being used too often and too extensively to harass people of color, Black and Indigenous people. And also look at whether or not the vehicle's moving or stationary, because if you get into a situation where somebody's parked, the police don't just get the right to conduct a traffic stop on a completely lone parked vehicle. So probably all the Ontario people here are familiar with McColman. If you're not, this is a great Supreme Court of Canada case from late last year. It dealt with Ontario's Highway Traffic Act and the provisions there that allowed the officer to conduct a random stop to check sobriety, license, insurance, and found that it didn't apply on private property. Mr. McColman was jammed And the police officer actually follows him. I think it was a Max convenience store that he was leaving. And he follows him and he's like, I'm going to stop this guy to check his sobriety, but then doesn't. And doesn't do it until he pulls onto private property, onto a private driveway, and then activates his emergency equipment and conducts the stop. And the Supreme Court of Canada confirmed that these powers, these Highway Traffic Act powers, only extend to the actual moving vehicles on the roadway. And you have to actually start the traffic stop or try to do the traffic stop while the vehicle is still in motion. And if you look at all of the other traffic statutes across the country, they all are pretty much identical to Ontario's legislation in respect of their random stop powers. So you can rely on McCollman even outside of Ontario. I use it in BC all the time. And I'm sure the Crown is very frustrated at me for it. But our provisions are the same. This is a BC case where essentially those same provisions were considered. This predates McCollman, but it's still looking at both the statutory powers to conduct the random stops, to check license, sobriety, insurance, fitness, demand a driver's license, as well as the common law power. And Mr. Johnstone is like on the side of a highway in, I want to say like Coquitlam or something. And a police officer sees him there, pulls up behind him to check out what he's doing there, basically. And Mr. McCollman, turns out what he was doing there was having lots of drugs. So he got in a little bit of hot water, but no big deal because he was acquitted because of the Section 9 violations, because turns out you can't do that. If the vehicle's not in motion and even if it's parked on a highway, those random powers only extend to vehicles that are in motion on the roadway. So, this comes up a lot if you have people who are maybe sitting in the parking lot of a bar in their car and the police officer comes up and knocks on the window. You can argue that that's an unlawful detention. And you don't have to get into the more annoying arguments of care and control where you have to actually put your client on the stand and have them testify. You might be able to get everything excluded in the charter breach. And the other thing I like about stop-related charter breaches is that if it is like a care and control situation and you argue the breach, judges don't super love convicting people for like simple care and control. They don't love it because, who among us has not slept it off in our car a couple times, right? So it's the type of situation where you're like moral blameworthiness is really low. And if they can find an out, they will take the out. So again, the benefit of pleading as many charter issues as possible is you're giving the judge more outs for people who have low levels of moral blameworthiness who end up with unreasonable crown. Then we have this very, very old case, Brown and Durham, which talks about how even if there are genuine highway safety concerns involved, if police are conducting a traffic stop for discriminatory or otherwise improper purpose, then the stop itself is unlawful. So this is your seminal case on ruses in the traffic stop. If there's more than one thing going on in the officer's mind and one or more things in the officer's mind maybe aren't on the up and up, you've got a breach. This is an arbitrary detention. It doesn't matter that your client may have also done something wrong or also may be investigated for legitimate sobriety situations. So that's a good case to have in your wheelhouse. Now, arbitrary detentions can also be created in other ways. Ontario Court of Appeal, a case called Thompson, another case where somebody's parked and the police like box in Thompson's vehicle and then he can't leave and they say this creates a detention. The police were saying, well, no, he wasn't detained because he could have walked away. And they were like, well, no, you were standing in front of his door. He couldn't leave. He was detained. It's subjective, not objective. And then also I like this Kosoyan case, which is the obstruction case. I had a case this morning where my client was arrested for obstruction because when the officer conducted the traffic stop of his non-moving vehicle, he got out of the vehicle and the police officer found that to be very problematic for some reason. Ordered him back in the vehicle, and then when he got back in the vehicle, he started looking through his glove box, presumably to look for his license, and the officer then arrested him for obstruction. Nope. So, but we often see that where there's the arrest for the obstruction or the threat of the obstruction arrest. If your client's not identifying themselves, if they're not getting out of the vehicle or unrolling the window or whatever, if the officer's command is not a lawful command or isn't based in lawful authority, then your client doesn't have to comply with it. And as soon as the officer utters those "I'm going to arrest you for obstruction" words, you're into another breach. And if you've already got an arbitrary detention, you're compounding it with an unlawful arrest or a threat of an unlawful arrest, then you're only getting into better territory for your 24-2 argument. So look for some of the things that the officers do or threaten to do as additional breaches that create detentions. And then, since I think lots of people are probably in Toronto, a woman's home is her very overpriced castle. So oftentimes you'll get impaired cases that start with some sort of a civilian complaint, whether it's about driving or the jealous ex-wife who calls in the husband for drinking because she wants to get the kids. I don't know how many of those cases I've had, a lot. Or the bartender who calls in the patron that he's just overserved and she leaves and drives home in her car. Whatever the case may be, you have the police showing up and knocking on the door. And most people don't think of this as a charter breach, but in fact, it's not lawful for the police to enter onto your property to knock on your door if they're investigating a criminal offense. Now, it's a fine line, but there's two cases. So there's Calcetus from the Ontario Supreme Court. In Calcetus, the police sort of wandered onto the private property and then looked inside the garage/carport. It was like an open carport, and that was found to be an unlawful warrantless entry. And then this great case that came at the end of last year from the Saskatchewan Court of Appeal called Singer. And this one really thoroughly considers the implied license to knock and approach, right? A lot of people will say, it's not if the police officer comes and knocks on your door and goes, "Hey, were you out driving your car? Because we got a report," that's not unlawful. The Saskatchewan Court of Appeal says, no, it is. The implied license to knock and approach is meant to be used to give police the same permission that everybody else would be given. The type of permission that if somebody asked you, a reasonable person would say, yes, of course, feel free to come to my property, feel free to come enter onto my property for the purpose of conversing with me, to sell me vacuum cleaners or to drop off a phone book or whatever the case may be. I mean, nobody comes on anybody's property anymore. I guess political door knockers. But no reasonable person, the Saskatchewan Court of Appeal said, would ever, if they knew they were being investigated for a criminal offense, give permission to the police to enter their property. That's the type of situation where you don't want the police to come on your property. So no reasonable person would say yes to that. So that's not included in the implied license to knock, because that's not what most people would agree to do. Now, they do draw a distinction, which is why I say it's a fine line. And this is one where it's really going to come down to how you characterize it and how the police characterize it. So how you characterize it in your notice, and then how the police characterize it ultimately in trial, and how you force them to characterize it in cross-examination. Because there is still the implied license to knock and approach if the police are receive a report of an impaired driver and are following up on a public safety concern to make sure that the owner of the vehicle is safe and got home safely. So if they utter that magic S word of safety, they get away with things. And so Singer does say that. But as long as you can, get the officer to agree that they were there to investigate the complaint, and they probably haven't read Singer and probably haven't thought it through, then you're going to be okay on this charter breach. So this is also a great one for those post-driving consumption cases where, ever since they changed the criminal code, you can get in trouble for leaving the scene of an accident and going and drinking. I mean, you could before, because you could get charged with obstruction. So it was a stupid amendment that wasn't necessary. But this is great for that, because now it limits the police's ability to even enter onto the property, and it's going to limit the likelihood, again, of putting that evidence in at trial, having your client come and have to testify about this, which nobody particularly wants to do. with their client who fled the scene of an accident and then poured a couple drinks just to calm himself down, but didn't think the police were going to come. And of course, don't forget to touch the hood of the car, because that is a warrantless search. When the police find a car, even if it's like parked on the street, potentially, this could still be a charter breach. I don't have any cases on touching the hood of the car. Singer, they did, they were sitting in the car and there were some observations made of the car that were found to be breach. But there is a case. It's a weird case out of the BC Provincial Court, but it's a breach and it's jurisprudence on it. Where Mr. Gallegos Garcia is sitting in his car on the side of the road, and he's not sitting in it, sorry, his car's sitting on the side of the road. He's outside the car with his friend and they're changing a tire. And Mr. Nice Guy police officer pulls up behind him just to be a super nice guy, and probably not for any reason related to his status in the drug squad, and starts engaging with Mr. Gallegos Garcia to try and find out whether or not he needed help changing his tire. And Mr. Gallegos Garcia is like, no, you can go. And the police officer sees that the car has tinted windows. And of course, this makes him very suspicious, because why would you have tinted windows unless your car's full of drugs or guns? One of those may have been the case when the officer peered in the window of the car. And the court found that there was a privacy interest on what was inside the car in those circumstances. Part of what demonstrated the privacy interest was the fact that he had illegal tint on the window, but it doesn't matter. There is a privacy interest established in the contents of your vehicle, and an officer peering in the window to gather evidence might, depending on the circumstances, amount to a Section 8 violation. Obviously, you're going to have to contextualize it. If the car is parked on the street and the officer's walking by and it's something that anybody could see from a glance, that's probably not going to engage the privacy interest. If it's night and the car is parked in a carport garage at the back of a property and the officer has to put his hands on or shine a flashlight in, that's more in line with your protected privacy interest. But I would say anytime you start to engage with the vehicle, touch the car, touch the hood, touch the windows, as soon as there's touching happening or inspection of things that are much more require much closer inspection, that's when you're getting into a subjective privacy interest and a Section 8 breach. You're not going to get that in cases where officers run plates. I tried to argue this, and I had a case from Alan Gold where he also tried to argue it. So I thought maybe I was on good footing, because at least Alan Gold and I had the same thinking. But unfortunately, no judges agreed with either of us. So yeah, if running a plate does not engage a privacy interest, even though there's private information that is obtained, you essentially consent to having that private information when you purchase insurance and put a plate on your car. So there's an implied consent for that, and I haven't found any cases that get around that. If you don't plead it, you can't argue it. And if you don't argue it, you can't get a breach. And if you don't get a breach, you can't get anything excluded. So even if it sounds far-fetched, argue it. Make your best effort. And this also comes to things that you might think you might not need to argue, because there might be other ways within the trial proper to address them. Pardon me, I'm a bit of a cold. This happens a lot in refusal cases, where people think about the validity of the demand in a refusal case as an issue in the trial proper. If I can argue that the demand is not valid, then the refusal's out. But I always like to plead it as a charter breach, in addition to arguing it in the trial proper. And there's a couple reasons for that. The first reason is, doing it as a charter breach, you might not win on the breach argument, but you might set something up or get some sort of finding that might impact it on the validity of the demand, right? A court might say the demand wasn't valid, but it didn't amount to a breach for whatever many stupid reasons that historically judges have come up with to do this. Like I think one I read once was because he consented to it and provided a sample anyway. Okay, but under threat of prosecution, but I guess you overlooked that fact. So you might not get it to be a breach, but you might get a finding that's made that compromises the validity in a triable issue. And there's also differing burdens at play. You might not be able to prove a breach if it's, if it's dealing with a like a 10A or 10B issue. You might not be able to prove the breach, but you might still be able to prove that or raise a reasonable doubt as to the validity of the demand. So I like to do it both ways because it actually gives you two kicks at the can. And the other thing about doing it this way is if it is a refusal case and maybe like your client doesn't have anything helpful to say in the trial proper, but he might have something helpful to say about the interaction with the officer, and you don't want to put him on the stand to go, I don't believe in the law and I'm a free man and a sovereign citizen, and so I don't have to comply with demands. But you could put him on the stand in the context of a voir dire and get that evidence out without having to get into things that are going to have your client talk themselves into a guilty conviction. So you get to shield yourself that way while essentially addressing the evidence at the trial proper, and maybe sussing out how the judge responds to it if you want to call him again and get him to say the same thing in the trial proper. So demands. This is like your super basic overview of demands. There's two different standards on demands and delays. There's immediately and as soon as practicable. And these are charter issues. Invalid demands are always charter issues. There used to be, this is probably long before most of your time, there used to be this sort of debate. We called it the Rilling issue because there was this case called Rilling, which said that an invalid demand would lead to inadmissibility of the samples because the samples only come in by virtue of there being a demand. So you don't have to raise it as a charter issue. It's essentially a statutory compliance issue. And if the evidence is obtained in a non-statutorily compliant fashion, then it's not admissible. And Rilling was like divided at the Supreme Court of Canada, and then different provinces went different ways on how Rilling was applied, and often different ways between different judges within the provinces, and it got really confusing. So many of the sort of impaired driving lawyers just adopted the approach of pleading an invalid demand as a charter issue. Again, you can always fall back on Rilling. And so if you get one of those old school judges who's like, yeah, but what about Rilling? You can be like, oh, no problem. We'll address that in the trial proper. But it's actually not a good law. The Supreme Court of Canada kind of addressed it in the case of Alex, and I say kind of because they didn't go all the way. But they did essentially say, look, this is the whole point of the charter. This is why we have the charter, so that if the demand is not valid, you can argue that there was a breach. Now, a lot of people wonder, how do you characterize an invalid demand insofar as a charter issue? I like to call it a Section 8 issue. There's lots of cases that say blowing into a breathalyzer doesn't engage a privacy interest because you don't have a privacy interest in your expelled breath. You can easily deal with that by asking the officer about deep lung air. What's deep lung air? And that's more air than you would naturally expel in a regular breath. Okay, there's your privacy interest, right? And you get the air at the bottom of the lungs. It's not your naturally expelled breath, which, the leaning in, I think there was Singh from the Ontario Superior Court or Ontario Court of Appeal recently that the officer leaned into the guy in the hospital bed to smell his breath and then formed his grounds. And the Ontario court was like, that's fine. It's naturally expelled breath, but this is beyond that. So I always characterize it as Section 8. I have never had a judge come back to me and be like, it's not really a Section 8 issue, but don't worry, even if it is for an ASD, for roadside, it still engages Section 10A and 10B. And one of the cases I'm going to take you to on the ASD finds a Section 10A, 10B breach on the basis of an ASD demand that was not made immediately. So you also get into 10A and 10B. And obviously, once you get to the station and you're providing a sample in response to a breath demand or a DRE demand, 10B is going to either be waived or implemented, and hopefully not implemented properly, but it'll either be waived or implemented at that point, and then you won't be able to argue Section 10A and 10B, but you will be able to argue Section 9 because the detention at that point is solely for the purpose of enabling the samples to be taken. And you can very easily ask the officer a couple questions to make that out. You can say, Constable, the only reason you took my client back to the detachment was to do the breath samples. You released him once the breath samples were over. That's because the investigation concluded once the samples were provided. And if he had refused to provide samples, you would have released him immediately after the refusal. Is that right? Okay, great. And then you have, that is the sole purpose of the detention, which makes an invalid demand engage your Section 9 interest. Because if you don't have a valid demand, you wouldn't have been detained for the purposes of that. So let's talk about immediately. Immediately means exactly what it sounds like, not what the courts for a very long time in a post-Woods world were trying to make it mean. Immediately is your standard that's going to be used for ASD demands, both mandatory and suspicion-based, SFST demands, saliva demands, and it applies both to the making of the demand and the administration of the test. So it's paragraph 2 of the Supreme Court of Canada's decision in Bro, where they say that the immediacy requirement has both an implicit and an explicit requirement. The implicit is that the demand be made immediately, and explicit is that the test or the sample be furnished immediately after the demand. So the second immediately is really more on your client to provide the sample than it is on the police to collect the sample, but they have to provide that opportunity immediately, subject to a few limited considerations. So here's some important cases on immediacy, and maybe I'll just mute myself for 1 sec so I can sneeze, and you can read. Okay, sorry about that. All right. So Schmidt is this great case out of Yukon. I love this case because it is 3.6 minutes and it's all on body-worn camera. And the judge, it's like paragraph 84, I think it starts. Judge Cousins, he's the chief judge in Yukon. He counts the number of seconds that elapse between all of these very important events. And it totals up to 3.6 minutes. That is like no time at all. It is a beautiful, wonderful case for the defense. And he says this is a 10A and a 10B breach. And he even makes some cynical comments about how if you have to expect that the police officers are going to comply with the most basic and rudimentary obligations that are on them. So this is like a great follow-up to the 2023 Supreme Court of Canada decision in Bro. I'm pronouncing that incorrectly, I'm sure, which says that the immediacy requirement for ASD demands can only give way to investigative activities that are only necessary to enable a proper analysis to be made. So it has to be a reason related to the reliability of the sample. So mouth alcohol, obviously, burping, regurgitation, smoking, those types of things. Bear in mind, though, this is something that you should always plead, even if there's a justification for the delay, because oftentimes the calculation of the delay is not great. So your calculation, I see often police officers will be like, oh, they were chewing gum, so I decided to wait 5 minutes and then had them remove the gum. And then they take the sample 7 minutes later. Well, there's 2 minutes of unnecessary delay. So always plead it, even if the delay is very short. If it's beyond exactly 15 minutes, that's not immediate. And I mean, honestly, at that point, if you're standing there for 15 minutes to wait because somebody burped, you can start a timer so that you're not wasting any extra time and detaining anybody any longer than you have to. They also say that unusual circumstances are something that can be used to justify delay. And they refused to define what unusual circumstances was, which was very annoying, but also very good, because it leaves it to the lower courts to do it, which means you can invent whatever you want as a reason that anything that happens is not unusual circumstances. Like in McCorriston, where the Saskatchewan Court of Appeal considered the case of Mr. McCorriston. He's pulled over. I love the Saskatchewan Court of Appeal, by the way. They're doing great things. We do not deserve them. He's pulled over, and the police officer runs his plate when he stops him to know who's likely driving the vehicle, the registered owner. He goes up, lo and behold, it is indeed the registered owner. And he makes an ASD demand, And then he goes back to the car and runs the guy's information and then comes back and has him provide the sample. And he's like, well, I didn't want to do it because I didn't, I wanted to make sure who I was dealing with. And it's like, you already knew who you were dealing with. There's nothing to suggest that this person was a specific officer safety concern. And just wanting to satisfy yourself that there weren't any general safety concerns is not unusual circumstances. In that case, 5 minutes of delay. So another super short period of time that just running a background check, not sufficient. And that would apply to any case where the officer says before the words of the demand and the administration of the test are out of the mouth, can I see your license? If they've already formed their suspicion, or if it's a mandatory demand, you cannot do the license request. And we see this all the time. What's the first thing out of the officer's mouth when they walk up to the window? Can I get your license? And if they then read a mandatory demand after spending a few seconds shrivering your client, that is not immediate. That the immediate thing should be the mandatory demand in a mandatory demand case, and otherwise it should not be. And I didn't write a slide on this, but I maybe should pause here to talk about mandatory demands, because those engage all sorts of great charter issues. Don't try and argue that they're unconstitutional, because everybody has failed so far, including me, in getting that ruling. So I think that poor horse has been beaten to death. But the mandatory demands, be very careful when an officer uses a mandatory demand, because it is a breach. If they're going to read a mandatory demand, you're going to go into your whole warrantless search with the ASD, as well as the arbitrary detention, the prolonging of the delay to implementing and reading 10A and 10B. So you're going to engage 8, 9, 10A and 10B if there's a mandatory demand that's read outside the context of what an officer is allowed to do. And that means they must be in possession of the ASD. And if they're not physically holding it, I would say plead it. Plead it. If it's in the trunk of the car, plead it. Why did they have to walk back to the trunk of the car? There's an immediacy requirement and a requirement to be in possession of an ASD. Taken together, read contextually as a whole, as we interpret legislation, that's a breach, because they should have it in their hands so that it is immediate. Walking back and getting it is too long in the context of a demand that eliminates that suspicion requirement. So plead it in those circumstances. I almost got to argue it, and then I had a client that decided he wanted to plead mid-trial, and it made me so sad. I was like, no. The other thing that you need to know about mandatory demands is they are not supposed to be used unless a person is operating a motor vehicle. And if you go back to the 1990s jurisprudence on ASDs, you will find a bunch of cases that talk about is driving. They're literally called the is driving cases, because it used to be that the criminal code said the demand could be made to a person who is driving, and then they amended it to do the within the preceding 3 hours has operated or had care and control of a motor vehicle, and then within the preceding 3 hours operated a motor vehicle. The suspicion demand still has the 3 hours requirement. So the officer still has to have grounds to suspect that the person's operated the motor vehicle within the preceding 3 hours, as well as with alcohol in their body for an ASD demand. That's a suspicion demand. But the mandatory demand incorporates that old is driving language. And that is intentional conduct on the part of Parliament, that they want the demand only to be made to a person whose butt's in the driver's seat operating the vehicle, as that's defined in the code. So you can't roll up to an accident and mandatory demand somebody. You can't knock on the door and mandatory demand somebody. That is unconstitutional. You would not believe the fight I got into on TikTok with people about that. But yes, that is not something that is lawful to be done, because the is driving language. So if you ever get a case where the officer uses the ASD pursuant to a mandatory demand, plead it if they weren't driving. Even if there was some separation from their driving, like the officer got them out of the car and put them in the back of the police vehicle, plead it. Plead it. Plead it anytime their butt's not in the driver's seat and the engine's running and they have the keys. Okay. As soon as practicable. This is for all the other fun demands, all the evidentiary ones, breath, blood, urine, DRE, and then taking samples is also supposed to be done as soon as practicable, but the courts don't super love finding that that's a charter issue. Again, plead it. I plead it in every case that it wasn't taken as soon as practicable. that it was a charter breach. There's some Ontario cases that don't go my way, but I have a BC Supreme Court case that I lost everything in Supreme Court and on my on a summary conviction appeal of my trial win. And accept that point. So that, I'll take it. I'll take anything. So there is a BC Supreme Court on it. As soon as practicable, leading case, the Ontario case from 2006, Vanderbruggen. The crux of it, you don't need to read all this, you can read it after. The crux of it is very simple. It is that you have to be engaged in investigative activities that are reasonably necessary. If you are chatting with your colleagues while arranging a tow truck because they're going to sit on the car while you transport the person back to the detachment to do the samples, that's probably not as soon as practicable. If you spend a long amount of time figuring out what your client's dog is going to do or if the officer rather spends a long time figuring out what the dog's going to do when they impound the car, that is not as soon as practicable. It has to be reasonably necessary investigative activities. And if the officer forgets to read the demand, that is not as soon as practicable. They say they cannot be forgiven for forgetting the demand. So here's a bunch of good breath demand cases. Lots of them Ontario cases. Then there's Beckler from the BC Supreme Court. That's the second one there. And that one's very important also for Section 9 issues, because Beckler characterizes delay as violations of the as soon as practicable requirement squarely as a Section 9 issue. And specifically, they do it in relation to arrest. There's this whole discussion in Beckler about how Miss Beckler was arrested instead of detained and then read the breath demand. But the officer also forgot to read the breath demand until he took her back to the police station. And the Crown essentially said, well, she's arrested, so he had the right to take her back to the police station, so it wasn't an arbitrary detention. And the court says, no, not really, because it was arbitrary, because she wasn't committing an indictable offense. And I know you're thinking, but impaired driving is a hybrid offense. What are you talking about? The court says because it's pretty much always prosecuted summarily, they can't just fall back on an arrest without warrant for a person found committing an indictable offense and then take her back to the detachment. And they go through this whole analysis on it. So that's a good case for your Section 9 issue on the actual time it takes to take the samples as well. Because the breath demand itself incorporates that as soon as practicable language. So yeah, lead taking them after delay is a Section 9 issue, and get the officer to agree with that, and that will be much better. You might recognize this photo. It's in pretty much every CBC story about impaired driving, and that's my friend's finger in the photo. It's like the most famous finger that I know. Yay, bodily fluids, my favorite. Bodily fluids are so fun because they engage rare areas of the charter that we don't get to argue a lot in impaired driving cases, like Section 7. There's also, of course, Section 8 issues with respect to collection and handling of samples that are engaged. But I like the personal dignity arguments when it comes to bodily fluids. Because if you get bodily fluids on yourself, like your client is so drunk that they pee or poop or vomit or any combination of the above, that engages Section 7 personal dignity issues. And I cannot tell you the number of cases, like as women, you probably all understand this. I have had numerous cases where my female clients have defecated in their pants, and they have not been given something to wear at the police station and change into, and an opportunity to wash themselves. And I'm sorry, but that microbial environment that is terrible. And I write detailed charter notices talking about like bacterial vaginosis and things like that. Then I get a stay. Nobody wants to litigate that. No officer wants to answer questions about where did the poop go, officer? Where do you think it went? So yes, these ones are great. There's a Yukon case. Yukon, by the way, is like a really great ground for research for impaired driving cases because they have a lot of it up there, and they run a lot of it because the federal crown makes no deals and takes no prisoners. So KJH, breast samples were excluded after Miss KJH was filmed on the toilet at the detachment. So they had a camera in the cell and they took her to the cell to use the toilet. So didn't get bodily fluids on herself, just put them in the toilet, but they didn't have anything to prevent the cell guards from seeing her use the toilet. And even though there was like a privacy thing, it was added after the fact. So she was still filmed and watched doing her business in the bathroom. And that was a significant enough personal dignity breach to result in evidence of samples being excluded. And then in Reed, Mr. Reed pees himself. And this is essentially the test that the court looks at to determine whether there's a Section 7 stay in circumstances where somebody is their dignity is compromised by the actions of the police, and he got a stay of proceedings because of the profound effect on his psychological integrity. So if your client, does any bodily fluids on themselves, you can totally rely on that as a charter breach, and I think that you should definitely argue it any opportunity that you can get. Then there's issues, of course, with the collection and handling of samples. And this doesn't just deal with your blood or your urine samples. It also deals with your breath samples. Because if there's any sort of misfeasance in the way those samples are collected, you can argue that as a breach. I like to raise Section 8 when it comes to ASDs. I think I have the McGuire case in here. Yeah, McGuire. So in McGuire, it's about the officer's actual reliance on the ASD test result. And there's, again, conflicting authority from various appellate courts, but the Yukon Court of Appeal, which is also the BC Court of Appeal, kind of resolves this in McGuire and says that if there are objective facts known to the officer that make it unreasonable to rely on the result, then it invalidates reasonable grounds. Well, if it invalidates reasonable grounds, then you don't have grounds for an arrest, which means there is a Section 9 breach. You don't have grounds for a breath demand, if it's an ASD, which it was. And then you have a Section 8 breach. You have arguments to make that are grounded in the charter on the rest of what happens when it comes to these types of issues. And objective facts known to the officer at the time, all you need to do to establish these objectively known facts is set out this information in the manual, pin the officer to the manual. This is what I bring the manual to court. I bring the device to court too. And then you start to ask them the things that they say and demonstrate that they knew better. You take them right to the manual. So you were trained on this manual, recognize this manual, and it says this, and you didn't do that. And you knew that you were supposed to do this because this was your training, and they'll have no choice but to agree. And then you have objective facts that were known to the officer at the time that made it unreasonable to rely on the result. I think McGuire was a chewing gum case where the officer was like, oh, I didn't know I was supposed to wait. And they didn't get that admission out of him. But if he admits that he knew or should have known, then that is going to lead to a breach in the collection of a sample, which then will trigger further breaches. It's got this lovely cascading effect. There's also this like super cool case out of BC, which is Gallant, and it comes up a couple times. Gallant deals with breaches where the police don't file a copy of a warrant report and don't give it to the accused. So you have to file the warrant report 7 days after execution with the court, and a copy of the warrant must be given to the accused. Lots of times there's warrants that are executed in impaired driving cases, right? You have the warrants to seize the hospital samples. You have the warrants to seize the production orders to seize the hospital records. You get warrants for searching a vehicle that's been seized after an accident to get things like the automatic data recorder or the dash cam. Often, weirdly, they look for people's cell phone records to see if they were on the phone at the time that they got in the accident, to see if they can also lay a distracted driving charge, because, nothing like an overcharge. Or dangerous, I guess you could go with dangerous. So all of those warrants, like make sure that all of the procedural steps were required. Did they file their 490s on time? Did they go and actually get an extension order, or were charges approved before then? Because if they didn't do those things, if they didn't take those steps, those are all Section 8 breaches. And while they may not lead to the discovery of evidence, there is good 24-2 case law that talks about how these rules exist for a reason. And just, blatantly not complying with them is not acceptable in this day and age. So you can always rely on that. And then we have medical privacy, which is the most sort of complex issue, I think. Medical privacy really is going to come down to what the officers are doing at the time. So TL in British Columbia, this is not an impaired driving case, but I've had this pattern lately of Crown in accident cases with hospital samples that are later seized, or observations at hospitals or things like that with hospital involvement, where the Crown says it's okay for the paramedics to turn over the ambulance reports, and it's okay for the hospital to reveal information because of provisions of the Privacy Act that allow them to do so. And the court found in TL that the inadequacy of procedural safeguards rendered a law authorizing disclosure of personal health information to the state without consent a violation of Section 8. So anytime you have any medical information disclosed to a state agent, either intentionally or inadvertently, even if it is done under some sort of provision of the Privacy Act, if it's not done with a warrant, I mean, obviously, if a warrant, you challenge your warrant like your classic warrant challenge way. But if it's not done with a warrant or a production order, rely on this and rely on these other cases to say that this is a breach. There's also SS from the Ontario Court of Appeal, where the police are sitting in the ambulance while Mr. SS is getting his stuff checked out by the paramedics, and he makes some admissions to them that the officer then relies on for grounds. And he doesn't tell Mr. SS that he's detained or that he's under investigation. There's no 10A, there's none of that. He just kind of like eavesdrops or overhears, of course, this conversation with paramedics, and relying on the Supreme Court of Canada's decision in Taylor, the Ontario Court of Appeal extended this to say hospitals, not charter-free zones. Same with ambulances. You don't get to just eavesdrop somebody's medical treatment with a paramedic that they would expect to be private because you're gathering grounds. Sorry, not cool. It's a great case. Love it. And then you have your like very classic Supreme Court of Canada seminal cases on the hospital staff just disclosing things to police. I mean, Diamond is shocking. Diamond, like the Mr. Diamond cannot consent to anything because he's so injured, and so the doctor like just takes blood from him like without consent and then gives it to the police. Just gives it to the police. And then there's Dersh, and in Dersh, the officer doesn't get the blood sample, but the doctor gives him the medical report. And you'd think, oh, this was the 1980s and the 1990s. Doctors aren't doing this anymore. Yeah, they are. They are all the time. I had a case a little while ago where a nurse pulled the officer over to her computer and said, look at that alcohol reading. It's 4 times the legal limit. And showed my client's labs to the officer. And Crown ran it for a short while before agreeing that that should have been excised. Where do you get off doing that? Anyway, nurses are the worst. I know this. My mom and my sister are nurses, so I'm allowed to say that. They're the worst for violating privacy. They're like cops, but in an ER. And so yeah, watch what the nurses say. Get your notes. Get your officer's notes. Look to see if there's any notation about any conversation with medical personnel. And if they were in the room, I plead it. I plead a violation of Section 8 if they enter the trauma room. And I also plead a violation of Section 7. I say that they interfered with medical treatment, that they didn't seek permission to be in there or determine whether or not their presence would compromise medical safety. I don't have any cases on it, but you know, what if they didn't take any steps, how can you know? And you're going to force the Crown to have to respond to that and have to provide some explanation as to how they know that your client's treatment wasn't compromised by this big burly body with a gun standing in the room while they're trying to fix somebody who's just been in a serious accident. It was a stronger argument during COVID, not gonna lie. And then 10A. 10A is like my new favorite section of the charter. I love them all, but 10A has been my favorite lately because the courts have become surprisingly uncompromising on your section 10A right. And again, I think it's one that's often overlooked, where as soon as it clicks in that officer's brain, I'm investigating a criminal offense, the words need to be out of their mouth. And you have to watch because you can have in files often several Section 10A violations that happen in rapid succession. And I love that. It often happens in cases where the officer shifts the focus of their investigation. Beauchamp, this is a case where, like, in 5 minutes, the officer went from investigating the passenger of the vehicle who maybe assaulted his wife to then investigating Mr. Beauchamp for drinking 2 beers back there at the house where the maybe assault took place. And then she doesn't read the ASD demand or tell him what she's doing, tells him to hang tight, goes back to her car, comes back, asks him to blow, and he blows up at her. And the court's like, if she had told him what was going on, the investigation may not have gone in the direction that it did. And it's just a couple minutes. Beauchamp, I don't have a citation for it. It's an unreported case, but if you need it, if you're pleading a very shortened time 10A violation, email me, because I have one that's I think 2 or 3 minutes where it's called Toe. Mr. Toe walks out of a liquor store. The officer watched him drive to the liquor store, go inside, make a purchase, and come out, and thought he was walking kind of funny and smelled like liquor. Shocking, because he'd just been in a liquor store. And he stops him and then reads him an ASD demand. And it's like, doesn't tell him. He just stops him, asks him for his license, and then within 2 or 3 minutes, he's done the ASD demand. And the court's like, no, you needed to tell him the second you stopped him. You were investigating a criminal offense. And his refusal, all the evidence of him refusing that subsequent demand, excluded from evidence, relying on Beauchamp. So you can get 10A breaches on just a few minutes, as long as you make it clear that the point in time at which it crystallized in the officer's mind. West and Kessler are great cases. Kessler's a roadside prohibition case, but it's on the charter, and it's all about whether or not you have to advise somebody of a shift in your focus. So Mr. Kessler gets pulled over for expired insurance, and then the officer starts to form a suspicion, and he asks him questions about drinking, but he denies drinking. So he wouldn't think when he admits drinking that he would be asked to provide a sample. And because the investigation shifted from a legitimate traffic stop reason to a different type of investigation, that was a violation. Be careful with that 10A issue, though, when you're dealing with these cases of shifting focus, because you don't want to confuse the advising of 10A with a demand. If you have an immediate ASD demand, once the focus shifts, the courts have said that ASD demand itself constitutes compliance with 10A because it tells the person why they're being detained or communicates the shift in the focus. So it's better for a arrest demand case, or better for a case where there's some delay making the ASD demand, or where the officer is still gathering his grounds to make the ASD demand, and in the course of gathering their grounds, they're not advising of the shift, which is what happens in West, where Mr. West is in the parking lot of a 7-Eleven, and there's a mischief call, and the officer comes up and is asking him about that, and then suddenly starts to smell liquor and form his grounds, and doesn't tell Mr. West that this is changing now. And so, yeah, I always say it's a 10A breach, regardless of the reason for the stop. Always plead it. Doesn't matter. The officer's never walking up at the window and going, I stopped you for speeding. That almost never happens. Usually they're walking up to the window and saying, can I see your license, please? And if they do say that they stopped them for speeding, you still have your 10A when it shifts into impaired driving. There's no downside in pleading it, and even a few minutes can be enough to get everything excluded. I'm out of time. So here's some 10B cases that say that you have to facilitate contact with the lawyer at the side of the road. Yay. That's a 10B breach in most cases now, because it's very rare that the police do it roadside, and instead they take them back to the detachment and put them in the lawyer room and wait their sweet time to try and figure out whether or not they're going to contact duty counsel or give them a phone book. Not that anybody knows how to use a phone book anymore. O'Reilly finds that if there's delay implementing 10B because of booking in at the station, that's unlawful. And that might help in a case where 10B can't be implemented roadside because of officer safety issues, if that's a legitimate concern for whatever reason. Booking in, that's not an officer safety thing. That's administrative work. It doesn't need to happen before 10B. And also make sure that if it's like an ASD refusal, and they arrest them for the refusal and then release them on a PTA, that you're pleading your 10B violation for that arrest, and not implementing roadside. There's cases that say that you can't just release somebody roadside without implementing the right to counsel once it's been invoked. So once it's invoked, you have to implement it. There's cases on understanding 10B. Always make sure that your client understands what their right is. This Yukon case, Stewart is great for that. You can't just engage in a single-minded quest for a yes or no in response to whether or not they understand 10B. You actually have to like make sure that they meaningfully understand it. And if there's some confusion, robotically rereading the charter card is not the solution. It has to be communicated in a manner in which people understand. And if there's factors like Mr. CL, who wasn't taking his meds, that affect somebody's cognition that the police are aware of, like, oh, I don't know, being drunk or on drugs, you might need to take additional steps. So if the officer's talking about your client being grossly intoxicated, and then they get some sort of waiver and their evidence on understanding is a simple yes, you probably have a breach. And you can probably make it out because they're going on about how grossly intoxicated your client is and how they couldn't respond to simple directions to produce their license or state their name. As soon as your client's not remembering their address or spelling their name wrong, that happens a surprising amount, then probably they're not understanding the right to counsel. And you can get that out of the officer. Plead it. Go forth and voir dire. Okay, sorry, I just went a little long.
No problem. Thank you so much, Kyla, for this wonderful presentation. There are a lot of cases that are mentioned, so Kyla will be providing the slides later on, so don't worry if you didn't have an opportunity to write down all the citations. But thank you, Kyla. This is really very, very insightful. And we do actually have an award for a lucky attendee, so I will let Kyla pick someone. It will be a book from Emond on impaired driving. So one of you will be a lucky winner for tonight's awards. So Kyla,
Okay.
you can pick her name.
I'm going to pick someone I don't know, Zainab Etu.
Zainab Etu. Let me just see, I have to write down the name. Zainab, hi.
Thank you. I'm so glad. This is my first time winning anything in my life.
Well, congratulations. You will be winning the Emond book on impaired driving. If you can email me or WiCCD, and we'll send that, make sure that you receive your prize. So thank you so much.
Thank you very much.
You're welcome. And thank you all for being here tonight. So we do have our next session coming up. Let me just check. That was on Wednesday of next week.
Yes.
And so we will be on defenses in impaired driving cases that are not charter defenses. So that's in case like today you didn't have a charter argument, or you did make the argument and you didn't win, and you still want to proceed in the trial. So what kind of defenses can you still raise? And that will be the topic of next session. So thank you so much, Kyla. We know you were sick today, so we hope you feel better, but you still gave us an amazing presentation. So good night, everyone, and see you soon.